Good morning, everybody. My name is Dawn Lance. I'm with C-Tech Electric. I am your moderator today for our safety roundtable. I am the chair for the Safety Council for ABC, as well as a board of directors. I am not going to do introductions for everybody that's in attendance because we have a good group here today, and I'm really pleased that Karen has the support for this roundtable. I will let Karen introduce herself when she, after a couple announcements that we have. This, just to let you guys know that this roundtable is being recorded, so that if some people have to leave, like myself, we'll be able to come back and Tony will email us, or Janessa will email us the link so that we can get all of the information as needed. Also, we ask that you hold your questions to the very end and or put them in the chat room. Between Tony and myself, we will monitor them, and the questions will be asked at the end so that Karen can focus on her information that she's going to share with us today. And if you have otherwise, I'm just going to stop talking and let Karen go. Sorry, guys.
That's okay. No, thank you, Dawn, and thank you to ABC for asking me to speak today. A little bit of background about me. I'm born and raised in Washington, so a true native, one of the few, the proud. Was raised down in the South End and went to college at Whitman College in Walla Walla, UW Law School. And if if you could put on mute, that would be great with so many of us. That way we don't get the shuffling noises in the background. Thanks. I worked for a judge for a year and then the Attorney General's office for 14 years in the Labor and Industries division. So I've been handling labor and industries issues. I did 14 years representing labor and industries, including workplace safety citations and the like. And then ever since then, for about 16 years, I've been in private practice representing employers on all issues with labor and industries and employment law. So this presentation comes out of 30 years experience dealing with workplace safety inspections on both sides of things, and just some best practices for employers to get ready. So if there's one thing you take away from today, is plan now for an inspection taking place. Maybe you'll get lucky and you'll never have one and you spent a few hours getting yourself and your business ready. No harm, no foul. But most people who work in construction at one point or the other is going to have labor and industry show up, and you'll handle it much better and have a lot less anxiety if you do a little bit of pre-planning. Okay, and there we go. Did I miss one? Okay, so this is our presentation today, before, during, and after a government labor and industry safety inspection. As a brief overview, OSHA, the Occupational Safety and Health Administration, is the federal agency responsible for workplace safety in the entire country. And there are many states that simply allow OSHA to have the oversight and make sure that safety rules are followed in their state. There are a number of states, however, that are called state plan states. And that means that individual state wants to take ownership of safety in the workplaces. But OSHA still has oversight over those states to make sure that they're doing a good job and making sure that they meet or exceed the federal standards. In our state, our laws for safety are called the Washington Industrial Safety and Health Act, or WSHA, and those are the laws. And again, we have to meet OSHA protection or exceed it. So we're going to be talking about the inspections, and this is just a little bit of a roadmap to help you understand beginning to end on everything to do with WSHA or DOSH, Department of Safety and Health inspections. Something typically triggers the inspection happening. We're going to talk about programmed inspections, unprogrammed, complaints, referrals, an injury happening, something that makes the inspection take place. We'll talk about how the inspection is conducted, the various steps of it, how it's wrapped up, when citations are issued, how you can challenge those citations through the department reassumption hearing, what comes out of that, and appeals that go to the Board of Industrial Insurance Appeals, how that process works, and that's pretty much the flow beginning to end. And my subsequent slides will cover details on that. So some of the reasons why an inspection is going to take place is an inspector is driving around and observes a safety hazard. They look for plywood, they look for cranes, they look for construction materials, they look for construction trucks. They're looking for clues that construction activity is going on and that they should look and see if things are being done safely. If accidents or fatalities are reported to the Department of Labor and Industries, that most typically triggers an inspection. A complaint or referral is someone calling in about a problem, and sometimes they're just scheduled. So again, this imminent danger I just talked about, that's something that an inspector sees that is reasonably expected to cause death or serious physical harm. They see trenching without a trench box, people working on roofs without proper fall protection. Any of these things, the person's going to stop and try to open an inspection because they're observing imminent danger. Again, if there's a death, a catastrophic event, serious illness or injury, anything like that, that can trigger a department inspection. And sometimes they will look at Twitter feed or things from fire departments and other first responders to a work site. They'll also pay attention to that and send someone out if they see that there's a serious incident that's occurred. There's two ways people can call Labor and Industries to initiate an inspection. A complaint is one made by an employee, and the Department of Labor and Industries prioritizes complaints from employees about a problem in the workplace as opposed to a referral. So a referral is a non-employee calling Labor and Industries saying, hey, I think there's a safety issue, you should go out and check it out. Now, I see competitors sometimes in construction making referrals to get their competitors in trouble. So I see it happening in roofing. Also, if you are a non-union employer, I've seen for many of my clients that the referrals are made by unionized workers who are hostile to there being a non-union employer. So Puget Sound Energy may call Labor and Industries if they observe construction activity too close to power lines or whatnot. So just to know that sometimes there's political reasons why referrals are made as opposed to a true concern about safety, either trying to get competitors in trouble or to make life difficult for non-union employers. I've seen there be motivations other than strictly safety why people might call Labor and Industries to initiate an inspection. There are just scheduled inspections. So if you work in a high hazard, high claim industry, you can expect to be on the schedule of the department coming out and checking out your operations. Almost everything with construction is considered a high hazard. So construction gets way more inspections than, say, my law office, right? I've never had Labor and Industries come out and do an inspection. Why? We're a low hazard industry. No one's ever made a complaint or a referral. They've got limited resources. My guess is I'll go my entire career without Labor and Industries coming out, at least knock on wood, hopefully. If you're in an industry where your industry as a whole has increased injuries, they do data analytics at the department, all of a sudden hairdressers and hair cutters are getting more injuries and more claims, they might say, hey, let's do some more scheduled inspections in this industry and find out what's going on and see if we can get in front of why there's more claims and more injuries happening in this particular injury. Even if your particular industry isn't having increased claims, if your own company is having increased claims, your EMR was a experience modification rate, a reflection of your workers' comp history. If that went from a 0.6 to a 0.9 to a 1.2 over the course of a couple years and you had increasing number of claims, that might trigger the department to come out and do an inspection to find out, is this really an anomaly, or is this an employer who's having trouble with their safety practices and we need to get in front of it? And sometimes it's just your number is up, that, you know, maybe there haven't been increased claims, there haven't been complaints, but here's an employer in a high hazard occupation. We haven't inspected them in 10 years. Let's go out and see how this company is doing. If there is an accident on your work site, you are obligated to preserve the scene. So you're not allowed to go and move things around to make yourself look better. You have to leave your tools and your equipment and the scene of where the incident happened intact for the department's inspection. Of course, if you need to move things to give first aid, remove the victim, make sure other people aren't hurt, you can do that. If the fire department or the police come out, perhaps it's an arson investigation or other reasons like that, the fire department and the police have priority. They have jurisdiction over the work site, and Labor and Industries has to take a back seat until the fire department or the police department releases the scene for the Department of Labor and Industries to do their inspection. This can sometimes be helpful and buy the employer time, because the employer is allowed on the work site and can do some of their own work before Labor and Industries gets on site and begins theirs. But just to know, that's the pecking order of priority for investigations if there's been an incident. Now, you are required as an employer to report certain types of injuries and incidents to Labor and Industries. If there's a fatality or inpatient hospitalization for treatment, that has to be reported to the department within 8 hours. Note that if you go to the hospital just for observation and evaluation to find out if you've been injured and need treatment, that does not trigger the 8 hour. It's when you are admitted to the hospital or that you've gotten treatment. So if someone just goes to the hospital in an abundance of caution, they do some x-rays, they get checked out, person's fine, they get released to go home, then that does not trigger it. But if they are admitted for treatment, then you have to notify the department within 8 hours of that. Now, this is just Labor and Industries regulations. I will note, as an employer, if you have a serious fatality or injury or something significant goes down on your job site, you should consider notifying your insurance broker and your insurance company, especially if there's going to be any third-party liability, non-employees were involved, if there's workers from another subcontractor or the general contractor, if there's going to be a big investigation, possible lawsuits down the line, one, you have an obligation to notify insurance, and sometimes your insurance policy will pay for legal fees handling the Labor and Industries inspection. That happened to me a few times in the last year where there was a major event. There was a general contractor, numerous subs, numerous fatalities, that the insurance company would pay for my fees to handle the inspection, because if I can minimize a citation from the department or get a no violation finding, that's going to have huge savings down the line when there's the eventual lawsuits about who was responsible for injuries and damage down the line. If there's an amputation or loss of an eye, you have to notify the department within 24 hours. And to note, amputation does not mean you have to lose an entire limb. If you have someone lose the tip of or the end of their finger, that's considered an amputation. You have to notify the Department of Labor and Industries. Crane rules. Cranes have been a big focus of the department ever since there was a big incident in Bellevue 15 some odd years ago. Of course, the recent one down by Lake Union has only amplified the department's emphasis on crane safety. You should look at the crane regulations, but if you have a crane or operating a crane and pretty much anything happens to it, you're most likely going to need to notify the Department of Labor and Industries, and you can email the department. I like that because then you have a written confirmation of when the notification was sent. So they did change these rules within the last couple years about when you need to notify if there's any damage or problems with the crane. I could do an hour presentation on just cranes, but just to let you know, when in doubt, look at the regs. You're probably going to have to report an incident with a crane. So let's talk about the stages of an inspection. The protocol for department inspectors that they're supposed to approach the work site, show their credentials. I'm a compliance safety and health officer from the Department of Labor and Industries, and I would like permission to inspect. We'll talk a little bit more about how to handle that. Then they have an opening conference. You can delay the opening and giving that permission until you get one of your key employees on site to handle it. So again, you're going to want to train people. Don't be scared. Don't freak out just because a labor and industry inspector shows up. You train your people to say, I don't have permission to open the inspection or allow you to come on. I'm supposed to call our safety director or our safety consultant or whoever you designate. And Labor and Industries knows they're supposed to allow reasonable time for the appointed person with authority to open it. If you have working foremen or people without great language proficiency nodding their head and granting permission to open, the inspection is not going to go as well as if you have a trained person who understands safety, understands Labor and Industries out on site to handle the inspection. So this is that preparation. You need to train your employees, superintendents, management, everybody. This is how our business is going to handle things if LNI shows up. And it means you don't just nod your head and say, sure. You say, these are our designated people who can handle that. So if LNI arrives, get on the phone with your safety director, consultant, whoever you feel is in the best position to represent your business if there is an inspection. Then when that person gets there, they can agree to open the inspection. Now, there's a little bit of negotiating room that you can give kind of partial or conditional permission, which is asking the inspector, why are you out here? Hey, we heard that there was an injury with the saw. There was an unguarded blade and someone cut their finger. You can say, well, are you just going to be inspecting our cut operations, the saws, and then get the compliance officer to agree to a partial inspection, and then that's the limited scope of approval. That prevents or can help avoid a comprehensive top to bottom of the worksite inspection. Now there is a DOSH directive, Department of Safety and Health directive at Labor and Industries about focus inspections at certain work sites if you're a member of certain industry associations, of which ABC qualifies. So if you are part of the ABC safety team or safety, Tony will tell me later, or it's on the next slide, the name of your safety group, you automatically can ask for a focused inspection only on the area where there's potential hazard or a problem. And this is the benefit of being part of industry associations with vigorous safety programs, is you get the benefit of the doubt for that. So if you are an ABC safety member, you want to have proof of that. You have a banner at your workplace. Tony, a question I'm going to want to ask at the end of this presentation is, how do people prove that they're part of the ABC safety program and have passed all the checklist for that? If you have that, then there shouldn't be a comprehensive review of your written records and programs. The presumption is if you're part of the ABC blessed program, those types of things have already been checked out. They're only going to be looking at what was the alleged safety hazard. Another benefit you get is if you're part of one of these designated industry programs is you should not get cited for general violations. You should only get cited for violations that qualify as serious or greater. And the compliance officer, if the compliance officer wants to expand the inspection beyond focus, the one small area of concern, they have to go get their supervisor's approval if you're part of the ABC safety program. And if you're not part of that, then the inspectors just follow the protocol and their normal compliance manual. So it's a real benefit to be part of ABC's safety program. You can be removed from it. So they can say, look, we're taking you off that list. You don't get the benefit of the doubt of this program. If you're having repeat serious, willful, you're on the severe violator program, or conduct that interferes with the inspection. So we'll cover this later, but always be professional, always be polite, even if the inspector's behavior might be less than professional. Take the high road, be respectful, be responsive. You don't want to put yourself in a position that the department can show that you are interfering with the inspection or uncooperative, such that you don't get the benefit of your program. Currently, from my research at the department, these are the programs. Okay, it's called the Safety Alliance, Tony. I guess I got that down. So ABC's Western Washington Safety Alliance. There's also Inland ABC. The 2 AGC chapters in Washington have it, BIAW has it, and MCA has it. And my understanding, those are the only ones. So if you are not part of ABC's Safety Alliance, I've just shown you the huge benefit you get if you, I'm sure Tony has a checklist and criteria that you have to meet to be considered part of that Safety Alliance. What that means is you get narrow inspections instead of comprehensive. You're not going to have to show all your paperwork, and you won't get cited for general violations, only serious and greater. So this presentation is a giant commercial to talk with Tony and make sure your company's program is consistent so you can get in with the Safety Alliance, because it really gives you some great protections. So while the inspector has the right to do the inspection, you want to maintain control and have a plan for when that inspector shows up. So whoever might be front-facing employees with labor and industries, make sure they're trained on how to handle things, what your company protocol is. Technically and legally, you don't have to give permission for the department inspector to come do an inspection. You can require a warrant. However, talking with very trained safety consultants and experts and directors, as well as my own experience, it is very, very, very rare where that is a smart and strategic move to require a warrant. Because in most cases, they will go get it, and now they come back mad that you force them to go through those extra steps. You force them to go through that. When they come out, don't expect them to cut you any slack. And if they find out that you've been moving things around or trying to change the scene while you force them to go get a warrant, it does not go well for employers. Also, in this state, you have to work with labor and industries forever. It's not like you can get divorced from LNI. So your ongoing relationship with LNI really impacts your company's operations. They can come out once a week to your various sites and check you out and check you out and check you out. So I don't think it's in your best interest to get on their bad side. Should requiring a warrant get you on their bad side? Maybe, maybe not. But I would suggest, in my experience, it doesn't serve you well typically. So again, what's the company going to say? Train people. Who is the right person? Make sure everyone has that person's name, cell phone number to get them out. You need to spend time doing a dry run across your entire company on how to handle an LNI inspection. and you want to make a good impression. So if you have safety briefing and safety checklists for people coming out, if you had someone from the bank or you had an architect come out, you have a list of PPE that is required on your work site, make sure the compliance, safety, and health officer goes through the same orientation, the same safety checklist, the same COVID questions, make sure they've got the hard hat, whatever your workplace requires. Doing that with the compliance officer shows that you take safety seriously and you know how to do a safety orientation on your work site. And again, professional and courteous. If the inspector goes low, you still stay high. So let's presume the inspector is granted permission to start. There's an opening conference. I'm here to look at this. Now it's time to go walk around the site or look at what the problem is. You want your safety person to walk along with the inspector. I suggest that sometimes there's more strategic routes to take than others. So if it's a large construction site and the problem with the saws is in the northeast corner, you might want to have the inspector enter the job site at the northeast corner as opposed to the southwest corner where the inspector is going to walk by the trenching and the scaffolding and everything else that's going on. Because if the inspector sees something that's out and obvious, the inspector's probably going to have to deal with it. If there's anything the inspector feels needs to be fixed, very courteous, hey, those cords are laying around, those are a tripping hazard, whatever the case may be, quickly get on it, quickly fix it. Often you won't get cited if you have a can-do positive attitude of attending to more minor things right in real time. If you don't involve an attorney and you're not getting advice and they're not consulting, anything you say or write or photographs you take while the inspector is out on site, there is no privilege to it. And the Department of Labor and Industries can demand that you give that information over, either during the open inspection or later if there's an appeal of the citation. So it's kind of a fine line. So if my client called and said, hey, the department's coming out, there's an inspector, what should we do? And so now they've asked me to advise them, I might say, well, take photos as you're going around with the inspector and send them to me to review so I can give you advice on this inspection. Now those photos are protected by the attorney-client privilege, and we wouldn't have to give them to the department down the line. But if you're not involving legal counsel and the inspector measures a trench with the tape measure at an angle, such that we could argue later, hey, that measurement's not accurate, it wasn't perpendicular, but you go in with your tape measure perpendicular and take a picture that shows the trench was 4 feet 8 inches, you might just have created proof that you're in violation. So be careful what you document, that you don't create evidence that will hang yourself down the line. Again, also getting statements from employees. If you get those and you ask better questions than the inspector did, and the department says, we want your investigation notes, anything you got from the workers, you're going to have to give them to the department. Whereas I might say to my client, hey, I would like you to interview these employees and send me the information from those so I can give you advice on this case. Now those statements are protected by the attorney-client privilege. So just be careful what you create and document if you're not using legal counsel, because you will likely have to turn it over if the department asks for it. As far as employee interviews go, my experience in the 30 years I've been doing these cases is that I see sometimes leading or coercive behavior by compliance officers when they are one-on-one with a worker in private, asking leading questions such as, well, wouldn't you agree that there's inadequate training because such and such happened? Or just, I don't know, other questions that I don't feel are truly fact-finding. They're more agenda-driven. The department technically has the right to interview employees in private, but employees have the right to have a union representative or someone from the safety committee there as well. So you want to educate your workers well ahead of a labor and industries inspection happening, that if LNI comes out, that the employee gets to choose whether they want to talk one-on-one with the compliance officer or not. If the employee doesn't want to, the DOSH compliance manual tells the inspector, let it go and just move on and talk to other employees. So you can tell employees that that inspector might want to talk with you one-on-one, but if you say, I don't feel comfortable unless my safety director's with me or whoever, and I don't really care who else is in the room, I've just found when there's someone else there, that keeps the inspector on a more professional and fair level, because there's a witness to the type of questions that are being asked, body language, things of that nature. And you want your workers to only talk about, what led up to the incident, and tell them, like, you're not an expert. If they ask you to speculate or guess, you can answer, I don't feel comfortable speculating or guessing, right? Here's the facts as I know. This is what I saw. I don't want to guess about anything else. The employees are going to be asked about their training, right? So you want to train your employees, hey, if labor and industries ever comes out, they're probably going to ask about some safety issues, such as what training you have, how do you know how to do your job, when and where and are safety meetings held, who would you report a hazard or an injury to? So you just kind of want to run through those questions with your employees ahead of time. Hey, your safety training is, we review the accident prevention program when you're hired. We have our Monday morning safety talks. We have a safety consultant that comes out. You have experienced people who do hands-on mentoring training. Just kind of coach them on the training you are giving them and how to describe that if they were asked about it. Also remind people, our safety meetings, this is our committee, this is when they meet. All hazards, as you know, hazards and injuries are reported to so-and-so, because if the inspector asks them and the employees are like, I don't know, all of a sudden your safety program doesn't seem as solid as it might be, because they can't explain what the department considers are basics. So when the compliance officer comes out, ask for his or her business card. Typically their email and their cell phone is on there. You might need that later for sending documents. And for sure, for me as an attorney, if you're going to ask me to appear or participate in the inspection, I'm going to want to know who I'm dealing with and their contact information. And I have texted the compliance officer, FYI, this is Karen Forner. I am legal counsel for this company in this inspection. Please do not interview or talk to any management people until I can be present. And please please send your request for any documentation to my office, and I will get it to you in a timely manner. And that kind of just stops the questioning and the document request, because they have to go through legal counsel once they get that notice of appearance. And I've just done it straight through with a text or a phone call. I tell my client, put me on the phone with the inspector. Hi, so-and-so, I'm going to be representing this client. The department is going to ask for documents, photos, all kinds of things. One thing to keep in mind, is there anything that is confidential or trade secret? Sometimes there's high-tech companies where their work sites have confidentiality clauses. I know sometimes at Boeing, especially if you're on military side, a lot of confidentiality. Just be double checking what you give to the department, or get some assurances that it will be treated as a trade secret or confidential before you hand it over. And this list here is an example of some of the things that you might be required to give the Department of Labor and Industries. So you are required, after a serious incident or a fatality, to do your own investigation. And the WAC requirements are listed there at the bottom under 800, 3/2020 through 3/2025. There are a lot of technical requirements, and even my more sophisticated clients sometimes miss out on how to do that. The injured worker's supervisor is supposed to be involved, and someone from the safety committee, and there's a checklist of who's supposed to be participating in an investigation. Just if you have something really significant where the department is going to have scrutiny on what you did, be sure to check those WAC requirements. And again, be careful what you put in this report. It can and will be used against you. So especially if there's a big incident, a fatality, I suggest that you keep it as narrow as possible, no guessing, and ideally get feedback from an attorney. That way your drafts are protected as attorney-client privilege, or talk with a safety consultant before you finalize that report. So after the inspection takes place, there's a walk around, there's been the interviews, documents have been received, the department will set up a closing conference. It typically is not the place to argue about the proposed citation. If you've got an inkling of, or the compliance officer sits down and says, we're going to cite you for these 3 serious violations, and they're under the wrong code, your business doesn't operate under that code, you can respectfully say, I think this one should not be cited. It does not apply to our operations. It is a chance to, again, show your company in the best light. If there was a need to abate certain hazards and you've done so, point out that you've done it, bring proof that you've done it. You can ask clarifying questions. But at this point, pretty much it's been reviewed, what's done is done, and it's just gathering information, seeing what the department is proposing, and take good notes. Then the department will issue either, if you're lucky, a finding of no violations from the inspection, or you will get a citation that can have a variety of different violations. General violations typically don't have money assigned to them, although sometimes there can be a penalty involved with a general. And these are violations that are kind of paperwork, technically one of the Washington administrative codes, the WACs, has been violated, but it doesn't cause death or serious physical harm and doesn't have a direct relationship to their safety and health. Serious violations are the most common violations that the department issues, and that's when there's a substantial probability that death or serious physical harm could result from a condition which exists. It doesn't mean it did, but it could. So we'll talk a little bit later about the 4 elements the department has to prove to back up a serious violation. Willful violations. These are becoming much more common. Osha did an audit and review of Washington's programs a few years ago and basically said, Washington, you do a great job of partnering with employers. You have consultation, trying to get employers to be safe, but your stick, your penalties, your violations are too weak compared to what we would expect. So the number of willfuls has gone up and the amount of penalties has gone up significantly from 4 or 5 years ago. So if you are remembering what Wish and Dosh did 4, 5, 6, 10 years ago, it's a different playing field now. So you're going to see more willfuls. And that doesn't mean you meant to hurt your workers. It just meant you willfully disregarded the WAC requirements or just were plain indifferent to them. If there's a 3 times repeat of a violation, the department will automatically review it as a willful, because if you've been cited for fall protection a 1.5 years ago and you were cited for fall protection 6 months ago, the department's argument will be is, the WAC requirements, you have to make your workers follow the rules. Here we are again on the 3rd time and you're not making it happen. This might meet the standard for willful. Repeat violations, you can have a repeat serious, I don't know if I've seen repeat general. Probably I have, not as common. But that's when you've got a a substantially similar hazard where there was a previous citation within the last 3 years. It doesn't have to be the exact same WAC code, but substantially similar hazard. And that ups your penalties and again, creates a little bit of a track record, taking you down that dangerous road to a willful. You can also get cited for a failure to abate. So if you got a violation that says you are supposed to fix this problem, and this problem by this date, and you don't get an extension or you don't do it, there are significant fines the department can penalize you with for failure to fix the problems they told you to fix. A growing trend across the country and including in Washington State are criminal violations. Up until a few years ago, there were very few criminal prosecutions, and even so, it was just for money. You would have to pay penalties. Now there are people where they're seeking jail time, criminal charges, especially when there's a fatality. And so just to know, the department is putting more and more skin into how hard they're going after employers, especially when they feel they are repeat offenders and just haven't gotten the memo. Now there is a get out of jail free card or a defense called employee misconduct defense to a wishless citation. I'm going to talk about that because many employers are like, hey, I do a great job. It's the employee screwing up. I shouldn't have to pay this penalty. What's important to remember though, it's unpreventable employee misconduct because otherwise employers would get out of every single case because it's always an employee not following the rules that results in a safety violation. You have to show the employee not following the rules was unpreventable. And you have to do that by proving 4 elements: that you have a thorough safety program and work rules designed to prevent the violations tailored to what you're doing, that you communicated the work rules, you try to discover and correct violations, right? You have some carrots and sticks and consequences if people don't. And that overall, your safety program is effective in practice, not just looks good on paper, it actually works. So you're gonna have to document all 4 of those if you wanna get out of a violation with this defense. A little bit more detail, what does your safety program need to include? Clear work rules. It's gotta be tailored to what you're actually doing and the hazards in your workplace. You have to have training. You have to have the right equipment. So your safety program needs to check out on a 360 basis. And you have to have proof of that to show the department. Again, the most beautiful paperwork program in the world that your employees don't really understand or don't know about isn't going to count. You have to show it was communicated, that there's signage, that they had training in a language they could understand. So if you have a bilingual workforce or English as second language workforce, you may need to prove that it was communicated to the workers in their native language that they could really understand. And you can't just say, well, it's common sense that people would do it. You have to show actual training on your program. On the discover and correct violations aspect, you're going to have to show spot inspections either by an outside safety consultant or someone in your company that and again, if it's only once every other week, your operations are spread out, the department might say that's not really enough. Or if it's always on a set schedule. So if one workplace knows, oh, the safety person always comes out on Tuesdays, we know it's free game Wednesday through Friday, the department might not find that to be effective because it's those unannounced inspections that really can see are employees following the rules or not. So if you have disciplinary records and any records to show you really are trying to make sure your employers are doing things right, that's going to be helpful. So once you've shown your program has some teeth, you discipline people, you reward people, all that, you still have to show it's effective in practice. So if you have a number of prior safety violations, the department might say, look, your paperwork looks great here, but for the size of your company, your safety track record is terrible. We're not giving you the unpreventable employee misconduct offense. Also, what's helpful is a low experience modification rate. So if you're in the ABC retro program, understand your EMR. Industry average is a 1.0. So if you're above that, that's not going to be very persuasive that you have a really effective safety program, because you must be having more injuries and more severe injuries because your experience modification rate is high. If it's lower, I would say that's strong evidence that our program is effective, because look, our EMR is lower than the industry average. So it's very paperwork intensive, and you're really going to have to sell your company and its program if you want to try to get out of a citation with the unpreventable employee misconduct offense. The playing field has also changed for general contractors and upper tier contractors in the last few years. In the old days, if there was an upper tier or general contractor getting cited for the misdeeds of a subcontractor, it was just a safe place violation, kind of a generic violation. Now the department is going to cite the upper tier or general contractor for the exact same code of the subcontractor. So if the subcontractor gets a fall protection, the upper tier or GC will also get a fall protection violation. And this creates more risk of repeats, willfuls, and even getting on the severe violator list for upper tier and general contractors. So the bigger your company is, the more risk this new policy is. Let's say I'm a huge contractor and I have, we build houses in Spokane and Tri-Cities and Yakima and Bellevue. Well, if I have roofing companies in Bellevue and Yakima who had fall protection violations, and that goes against me as the GC, if there's a third one in Bellevue, that might be first time for those 3 roofing contractors. This is the third one for me as the general contractor. I might be looking at a willful. So if you're upper tier or general, just know there's more risk of your record getting dinged under this new policy. If you are a subcontractor, know that the people hiring you have more exposure because of this. They're going to be very mad if you get a violation. You want to look at your contracts, at what kind of teeth they're putting in, of what you might owe if you get a citation. And they may not hire you if your safety record is bad, because it just is too much exposure for them. So as we talk about your EMR and your safety record, it's just not the money you pay out. Your ability to get work and bid for work can be impacted if you don't stay in front of both of those. So I guess the way the Department of Labor and Industries is approaching safety is good for my business, because the stakes are higher for employers and general contractors and upper tier. The penalties are bigger, the violations are getting more onerous, and the impact on your business operations can be more greatly impacted by it. So this is what our firm does. I believe we do a great job and have a great relationship with the department. If you're choosing someone else, though, make sure that that attorney has a good relationship with the department and can work cooperatively with other attorneys, because there are some attorneys who have made the department so angry with their tactics that the department straight out will never cut that employer any slack or settle the case if there's an appeal, because they want to discourage that kind of behavior. So make sure you're working with an attorney who has a good relationship with the department, because I've gotten sweetheart settlements for my clients simply because I've developed a good, respectful working relationship with the department. They know I'm tough when need be, and I'll go to the mat, but they respect that I'm honest and not doing anything sleazy or underhand, and my clients get rewarded for that. Another thing to keep in mind with inspections and safety in general, there is a law that protects workers for speaking up about safety, participating in safety inspections. If you retaliate against that worker, even if it's a no violation finding, or you're mad that they called the department, you find out, if you fire them or otherwise take action, they can make a complaint to the department. They have a department that will investigate that, and they can cite you for basically WSHA discrimination and then take you to Superior Court, guarantee you the worker will probably get his or her own attorney, who will then try to get attorney's fees, so on and so on. It's very expensive. So if you ever do get an investigation for workers' comp discrimination or WSHA discrimination, strongly encourage you to talk to an attorney to get advice on how to handle that. You want to win that case with the inspection, not wait to see if they make a finding against you or not. So let's presume the department issues a citation against you. Do you fight it? To be realistic, it takes time, it's stressful and distracting to appeal, there's cost to do with it. Sometimes you might want to think, how does this look to Labor and Industries if I appeal it? Also, how fair is this citation? I've had clients say, Karen, should we challenge this citation? And it's one serious for fall protection when they had 3 people out on a site working without a fall protection work plan, didn't even have the fall protection gear on site. And I said, pay that fine fast and run, because if anyone else at Labor and Industries looked at the facts of this file, you could be subject to it getting much, much worse. So sometimes you want to cut your losses. I mean, it's good to look at it and see what you're dealing with. Maybe you got cut a break and you should just take it. But again, sometimes even if the facts are pretty strong for the citation, if you are going to lose your ability to bid work, or you're right on the brink of the next one will be repeats or willfuls, you might want to try to challenge it and see if you can get it reduced or vacated. Going back to the flow chart we talked about earlier, we've talked about the triggering event, the inspection, citation is issued. If you see the arrow going off to the right, you can challenge your citation at the department, at a department reassumption hearing. Again, this is not a neutral judge, it's within the same agency, but it's a second set of eyes on the citation to see if it can and should be modified or settled. When you do appeal it to the department, you're looking at a citation. The citation is pretty basic. Here's what we think the WAC code you violated are, the severity, the penalty. That's not everything the department has, but you need to appeal that citation within 15 working days of getting it. We've had clients who lost their appeal rights because they had a receptionist or somebody sign for the citation and that threw it in someone's inbox who was on vacation for 3 weeks. The person comes back from vacation, the 15 days is run, but you had someone from your business sign for it, you are out of luck. So you want to make sure whoever processes the mail, whoever signs for things, if there's something from the department, that gets to someone who can act on it promptly, because the rules are very strict on your deadlines. If you appeal a citation, also send a request to the Public Disclosure Unit at the Department of Labor and Industries. You want to get everything. You want the photographs, you want their notes, you want everything you possibly can to say, hey, what evidence does the department have to back up this citation we got? So if you were on a work site and you are a plumbing contractor, but you know that there was an inspection against an electrical contractor, the drywall contractor, and the general, if you really want to go at it, ask for the inspection files of all the other people too, so you can see the big picture of what was going on at the work site and what the department thinks, who did what wrong. And when you do your public disclosure request, it's good to mention in there that you're appealing the citation. That sometimes can get you a more prompt response, although they are really backed up. To get ready for the reassumption hearing, these are being done by Zoom or Teams now. I'm anticipating later this year they'll be back in person again. They're fairly informal. It's a department employee, usually dressed fairly casually, in a conference room at one of the Labor and Industries offices. They will record the reassumptions conference. Remember, it is not neutral, and nothing that you give the reassumptions officer or what you say in that hearing is confidential, and it can be used against you later unless you get an attorney and say, the attorney can say, this is an evidence rule, 408, settlement conference to resolve it. Then you can make the argument that it can't be used against you later. So that's but if you're not using counsel, just be careful of what you give the officer, what you concede, it can be used against you later. I talked earlier about, for serious violations, what the department has to prove, and it's called HEC. They have to prove there was a hazard, an employee was exposed to that hazard, an actual WAC code was violated that applies to the operations and that employer, and that the employer knew or should have known of the hazardous condition. If any of those are missing, then the violation typically goes down to a general violation. So sometimes you can poke holes in any one of those and then argue that, hey, this should actually just be a general, not a serious. Reassumptions conference might be a good time to assert unpreventable employee misconduct defense that we discussed earlier. It's going to take some time to put that together, a cover letter of why it should apply, and then all your documentation that proves all 4 elements. At reassumptions, you can settle cases. Sometimes you get the big win where you get it, which is usually for an employer, hey, we want this vacated. Sometimes you can get that. More often it's a compromise where, you know, no one side is thrilled, but everyone can live with it. This can be reducing the penalty, reducing the severity from serious to general, maybe reducing the penalty and the severity. Maybe just portions of the citation are violated. And sometimes in exchange for this, the employer needs to offer extra steps that will contribute to worker safety. You will get no love from the department if you say, well, you tell me what you want us to do to give us a break on this. They're not going to do your legwork for you. You need to come with a proposal of all this extra safety things you're going to do, which is why they should give you a break on the citation. And whatever you put on the table has to exceed the department requirements. If you come in simply saying, look, we're going to meet what we're already supposed to be doing, the department is not going to be impressed. After the reassumptions conference, if you come to a settlement, they'll issue a corrective notice of redetermination, a CNR, very wordy, that's what it's called, that can memorialize the settlement. Or it could be the department simply is going to affirm the citation as it was written, or I've seen it come out where they increase the underlying citation that now it's even worse, but that's fairly rare. This second document, again, you can only appeal that to the Board of Industrial Insurance Appeals. That is the neutral state agency that reviews appeals from labor and industries, such as workers' compensation orders and corrective notices of redetermination and other matters. But again, that 15 working day rule applies. So when the CNR comes in, the clock is ticking on getting that appeal filed. And there's details in the CNR about how you appeal to the board. Once you get up to the board, it's a very formal process. There's other state agencies that are more informal, like Office of Administrative Hearings, where you might appeal an unemployment case. This is like real court. We have the rules of evidence, formal discovery. Really typically, if you're going to go the distance on an appeal to the board, you should get a lawyer for that. The only good thing for employers is even if it's you appealing, the Department of Labor and Industries has the burden of proof to prove the violations. And they just can't hand the inspection file to the judge. They have to start at ground zero and prove every fact and every element that supports the violation. So that puts us in a good position. When you go to the board, they do have a mediation process. And sometimes you can take the settlement that was at reassumptions that didn't quite go through and repackage and resell it at the board, because now you're dealing with the Attorney General's office as being the lawyer for the Department of Labor and Industries. And the Attorney General's office has limited attorneys, limited bandwidth. There's a ton of cases. They can sometimes advocate for the department to accept the settlement. And that saves you a lot of money versus going through the whole hearing process. So when do you hire an attorney? If there's a serious injury or fatality, I strongly recommend it. Many times I just consult in the background. So we don't need to come out guns blazing, we're the lawyer for this company, but I can just be coaching in the background of, think about doing this, maybe let me review these documents before you send them in. If it's a serious incident, I strongly encourage legal review of any of your reports before you finalize them. If you're going to the reassumption hearing, some people do it on their own, or they'll bring someone like Tony or a safety consultant with them. That can be effective. If it's more complicated, you might want to consider getting an attorney at that level. And then, of course, as I mentioned, at Board Appeals. So the severity of citations and the penalties are on the increase. Your ability to bid work and get out on job sites can be impacted by your safety record. So you want to have a protocol in place, train your people, even think about doing a dry run so that you're ready to go and handle things as best as possible. And this is my lawyer slide, that this is supposed to be general information. Some of you are clients, some of you are not, so nobody take this as legal advice. If you want legal advice on any particular matter, you can call me privately, which is a reminder when we get into the question and answer period, I can't give you advice about any particular case or situation that you're dealing with. If you're a client, I wouldn't breach attorney-client privilege by talking in front of other people. And if you're not a client, I can't give you advice. But we can talk about general concepts, general best practices, and I'm happy to do that. So with that, Tony or Don, whoever's on board, were there any questions that came up in chat that we should talk about now?
Yes, there were actually several good questions that came up in the chat.
Yay.
Let's see here. Somebody was asking, let's see here. Where was it? Somebody had asked about if your written program or APP, when the inspector asks for it, does it need to be in a print version or can it be available digitally?
I don't know the answer to that. My very strong suspicion is as long as you have it and it's been communicated to workers and they can reference it, that electronic would suffice, but I can't say that definitively, but that would be my expectation. That's an interesting thing, Tony, that we could maybe email Eric Smith about and just, I mean, best practices of construction is to go electronic, right? Like you take your picture and everyone checks off. It's just, it's easier, and it's 2021. Keeping paperwork records is starting to seem old school. So, but I can't commit that the department wouldn't require it to be in paper, but I think that's a good thing for us to find out, Tony, and maybe send out to attendees to see what the department says about that.
Next question. You know, are photos from the public usable as evidence when it's being submitted as a complaint?
My guess is if it came to a hearing and they knew who submitted it, when I was at the Attorney General's office, if Joe Public took a picture that shows the violation, I'm going to call Joe Public, bring him into the hearing. Did you take this picture? Was it on this day of this work site? I'll get it authenticated. I'm going to move it into evidence. You bet.
Okay.
I'm not sure, you know, if every assistant attorney general is as gung-ho as I am to win, but if you get one who is, there's no reason why they couldn't do that.
Next question. Can an inspector bully an employee to be able to open the inspection by, this actually happened to a member. The CSO showed up and told the employee on site, either let me on the job site or I'm going to go get a warrant. You need to let me on now. And
well, that I have heard of that happening. in that instance, the employee should call the safety director and put the safety director on the phone with the compliance officer. You know, this is partly training your employees what to do, because there's an option between let me on immediately or I'm going to go get a warrant, which is wait, which the compliance manual tells them they are supposed to wait, which is 45 minutes up to an hour. You can buy a little more time when traffic is bad. So I guess part of that is training for your employees to not say yes and not say no, to say, I'm not allowed to say yes or no one way or the other. I'm not authorized to tell you no or tell you yes. The only person is Bob Smith. Here's Bob's cell phone number. I need you to talk to him.
Okay. Another question that was asked is, if you're a member of Safety Alliance, can an inspector deny a focused inspection?
Well, by that department policy, what was it, 2.25? I can't quite remember. Thanks, Tony. They have to get supervisor approval. They would have to call their supervisor and purportedly have a strong basis why they're not doing a focused inspection. If you show your credentials and you're a member of it, Tony, I don't think it's the worst idea in the world to circulate policy 2.25 to your members and people on safety and keep that handy. Maybe inspectors, inspectors, they forget, some of them are new, they don't think about it. It really is a protection that you as an employer want to assert. Like if I was a safety person, I keep a copy of 2.25 in my truck. So if I'm coming out and coming on site, hi, I'm the person, I'm part of the Safety Alliance, just have it handy in my back pocket. We really love working with ABC. We've had all our safety programs checked out by Tony. The department very kindly is recognizing for that extra effort that we just have focus inspection on what a particular complaint or problem is. So, I'm set to get going, presuming we're only looking at the trenching or only looking at the machine guarding. And if the inspector's like, no, I'm going to look over this entire work site, then you whip out the policy and says, actually, you have to keep it limited since we're part of the ABC Alliance, unless there's some justification and your supervisor, buys off on that. They may not know, they might just be trying to bluff their way through. But again, this is you being trained and knowing how you're going to handle that. And it's a great benefit. You don't get generals. You don't have to show all your paperwork, and you get a focused inspection. That's a huge benefit.
Yeah, it really is. The only issue we've encountered since I've been with ABC is just with the inspectors not knowing what DOS Directive 2.25 is.
So keep it on your phone.
Yeah.
Keep the link, the link to the department policy. Keep that on your phone. Keep a hard copy in your truck. Yeah, it's
definitely a benefit when it comes to these, and especially given the current climate and knowing that they're out there hitting it hard, can definitely save you time. There was another question that came from the chat asking if interviews with the employees between the CSO and the employee can be recorded.
Well, you can't record anybody without their permission, right? In Washington State, that includes. So the inspector can say, do you mind if I record this? And if the worker says yes, then it's going to be recorded. That being said, if the employee doesn't want to be recorded, then the inspector can't. We'll just have to take notes and go from there. So again, that's reminding employees, you can go talk to the inspector. You have the right to insist on bringing someone if that makes you more comfortable. That being said, if you want to talk one-on-one with the inspector, if no one else is there, we're not telling you not to do that. And if the inspector wants to record it, you have the right to say, no, I don't feel comfortable having it recorded, although I'll talk to you, or you can agree to it. Yeah.
Would that also apply to the employer? If the employer is invited into the interview, would the employer be able to record it as long as they get the permission from all the other parties in the room?
Yeah, but I'm not sure how strategic that is. Sometimes less is more. Like I don't like creating more evidence, concrete, pinned down evidence that the department can use against us later. Usually the inspectors are lazy and their notes are terrible, and they don't get the employee to review and sign off on the notes they took. They usually just, their inspections are, hey, I talked to this person, they said this. There's no proof that the person said it. There's no proof that they got the whole story. And there's no proof that the employee reviewed what the inspector wrote down and says, yep, that's the truth, the whole truth, and nothing but the truth. That allows us to challenge it later and have the worker say, no, they didn't get it right, or they forgot that I said this. So I'm careful, Tony, about, the burden of proof is on the department ultimately to prove this violation. I don't want to create any more proof they can use against the employer as possible.
Okay.
Yep.
Hey, real quick, going back to that, that hard copy of proving you're part of the Safety Alliance. What was that you were 2.25? You said something?
Yeah, it's DOSH Directive 2.25.
Right.
Yeah. That my
Basically
slides. Yeah.
Reminding,
yeah.
Am I right? It's basically just reminding them that, hey, we belong to Safety Alliance and we'd like to keep this focused.
The nice thing is about the the directive was just recently updated prior to pandemic and released last summer. What they did in the updated version is they included language for what it takes to get into be recognized by DOSH or LNI, however you want to call them. But it also lists all the appropriate associations that are members of that are affected by that DOSH directive.
Right.
So having that, in order to prove that you are a part of one of those groups, usually it's having the logos, the banners, that's great. But what I have personally seen when somebody's been questioning whether or not somebody is a member of a group, such as the Safety Alliance, is they'll either call me directly to verify, or they'll go to our website and check the listing of all the members who are part of the group. So we do put all the Safety Alliance members on our website. That way it's easy for compliance to figure it out. And typically the phone calls I've gotten is, hey, we're doing an inspection. This company is claiming that they're a member of your Safety Alliance. We just want verification. We just want verification that they are current.
Okay.
And then it's a simple yes or no on my part.
Okay, thank you.
All right. Any other questions that came in chat, Tony?
Yeah, so two more. What do you do if you feel that an employee complaint or injury is fraudulent?
Oh, well, if they make a fake or a fraudulent safety complaint, there's really not much you can do. We have people who I think the air is bad, or there might even be sometimes slight mental illness, I think, that is driving some concerns about safety. Labor and Industries comes out, maybe there's nothing coming down on that employee for complaining about safety. That it would have to be pretty bad and nuanced. Our office fights workers' comp cases all the time that are fraudulent or shouldn't be accepted. You have the right to go to the mat. Just remember, your fight is with Labor and Industries to reject that claim. I mean, if the lying and the misrepresentation is egregious enough, then you can consider firing the person for dishonesty or fraud, but be careful, because then you're dancing right up against industrial insurance discrimination. People have the right to try to file a claim, but the decision's with the department. So just be checking with HR and safety before, just because you get a workers' comp claim rejected doesn't mean you have free reign to fire the worker saying, oh, they never should have filed that they were scamming the system. You'll probably need pretty egregious facts to get the claim rejected and have a basis to fire the worker at the same time. Employment law and workers' comp and safety all butt up against each other. That's one reason, if you look on the screen, the reason we do these 3 topic areas, labor and industries, workers' comp, safety, and employment law, is because there's constantly overlap. So if you have a worker with a bad back and he files a workers' comp claim, but you show that really you hurt your back putting in a new bathroom over the weekend, and you get the workers' comp claim rejected, you still have a worker with a disability, with a bad back. You are obligated under Americans with Disabilities Act and the Washington Law Against Discrimination to enter into the interactive process to see if that person can do their regular job with or without reasonable accommodation, or if there's a job that's open in your company that they can do as a reasonable accommodation. So don't just think because you win on workers' comp that you can wash your hands of that worker, because if you handle it wrong, you're out of the frying pan into the fire of employment law.
And here's another question that just came through. Can a subcontractor request a focused inspection if the GC has an inspection happening on the site?
Well, if there's going to be an opening or your particular company is being investigated, I would request an opening if that's what's happening. And if the GC is not part of one of the safety alliance or whatnot, but your company is, I would assert that if you're looking at my company as part of this, we are still entitled to a focused inspection. Yep.
Let's see here. Oh, now the questions are starting to come in. Will LNI ask for a written COVID prevention plan as part of the overall accident prevention plan?
I'm certain these days that if LNI comes out, I think they're more concerned about COVID than they are fall protection and some other things. I would argue that if you're part of Safety Alliance, that your written paperwork programs, you get a pass on inspection of those. I wouldn't go too hard to the mat on that in light of COVID. One is ABC has great proposed sample COVID protocol. Things haven't changed much for construction in months now. If you're not confident of your COVID protocol program, check with Tony, because it's been set for about the same, Tony, for what, 5, 6, 7 months now?
At least.
Yeah.
At least the past 6 months, there really hasn't been a whole lot of changes.
Right.
Only real changes have been to the being able to gather and have spaces occupying 25, 50%.
Yeah. Any other questions?
One last question, and this was kind of something that came from me. Is number of inspections related to scope and size of work? I mean, if you have a larger job, say you've got a apartment, a single or a 2-story apartment building going in, and you've got 3 separate buildings, how often should you be inspecting that job site? And how many, I know this came up with a member, and LNI came back and said that they weren't doing, part of their problem is that they weren't doing enough inspections. And they're like, well, hold on. We have our safety guy going out at minimum randomly once a week. And then we've got safety consultants coming out at least 3 times a month. So you've got at least 7 inspections. And they said, well, that's not relative to the size and scope of your work. Mm-hmm. And it's like, okay, where is that written that there's a certain percentage that you have to do? I mean, how does that?
Especially if you're trying to get out from unpreventable employee misconduct, that we have, sufficient things to discover and enforce violations and whatnot. It's what a reasonable person, a reasonable judge is going to determine was adequate. So it's shades of gray, Tony. Anyone who's engineering and likes a black or white answer, you're not going to find it on that topic. I'm a lawyer. I dance in shades of gray all the time. So I think it's super helpful if you can have someone who is on site, who's the designated person to also keep their eye out for safety as they're continuing to do their job, who can call the safety consultant if they see a problem or otherwise follow up. I think that is helpful, that there's, you know, someone on site who is partnering with or is eyes on the ground for safety beyond the 3 times a month or the once a week.
Yeah.
You know, you have to ask, does it pass the sniff test?
One thing might help is having foremen or leads, I should say, obviously a superintendent, but if the superintendent's really busy, I could see in a situation like that where a foreman actually keeps a detailed daily journal. So you're at least having somebody who's like, you know, we saw a handrail that was down and we put it up. Then Tuesday, the next, you know, stuff like that. It's throughout the week in addition to everything else that, Tony, you're talking about.
Michael, that is 100% on point. You know, you want to make the case of our whole company has responsibility for safety. Safety is everybody's job. And for superintendents or the lead workers or whatever, they are eyes and ears on the ground. They know what to do. They know what to enforce. And we back it up with these super high professionals coming in on this, you know, this periodic basis. And if you can have proof of let's say it's a superintendent that he kept notes, he talked to so-and-so, he sent someone home because they didn't have their hard hat, just any fine tuning that you have eyes on the ground, also enforcing safety, in addition to the really more comprehensive ones coming in, now all of a sudden that looks adequate. I think that's an excellent point, Michael, and that's where I've sold it before. It's not like everyone is blah, 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 we don't care about safety until those 4 visits a month happen. Those are in addition to, and to really beef up what we also have going on an ongoing basis.
All right. Well, we are winding down. So
Okay.
if anybody has any other questions, last call.
Well, I really appreciate, Tony, you and your team asked me to come present on this topic. I enjoy it. It's fascinating, and I always learn something each time. And within a week, I will know whether an all electronic access APP will work. I think it has to be accessible to the workers. I know we did have an issue once of MSDS sheets being accessible online, but then the issue was, is there cell service or Wi-Fi wherever workers are going that they could pull up and access the sheets? Because if that's not the case, then they don't have access to it. They would also need paper copy.
Yeah.
So I think if it's accessible and the employees can look at it and you have devices as ready available as paper would be, I think that would pass muster. The only issue about electronic is if it requires internet access to go look at it. Do you have the devices, and is there consistent cell service or Wi-Fi that they could indeed look at it whenever they needed to?
Yeah, I would agree there. I know there's some with different items. There's different, depends also on the CSO shows up.
Correct.
Because I actually had a client of mine in a former position who the employee had downloaded a copy of a owner's manual for use of a piece of equipment, because the actual paper copy was so deteriorated that nobody could read it. And when the CSO pulled him down and asked him about where all the information, one of the first questions they asked, where's your owner's manual? And it's like, oh, it's right here on my phone. They didn't seem to really care for that. They wanted to see the paper version on the piece of equipment. Splitting hairs there. I'm sure it didn't go very far in terms of the legal challenges, because my last involvement was as the owning entity of the equipment. It was getting ready to go to court, and I think they settled out because they never got the call to come be the witness to attest to the training and everything. So,
well, great. Well, my contact information is up here on the slide. If anyone wants to have a conversation or email me, feel free to contact me. And with that, thanks again for having me.
Okay. Hey, Karen, one last question. Will your PowerPoint presentation be available for people who attended today?
I think it's being recorded, and
Yeah.
so I'm just going to have people refer back to the recording if they would.
Okay.
I tend not to share materials for people who aren't my clients, just because sometimes it can get out there and be looked at or talked about or shared in a context where I lose control over what things are on there and what I say in context. So.
Yeah. No worries. All right. Well, we do appreciate you making the time to come speak to us. It was a great presentation, Karen. We really appreciate it. I want to say thank you to everybody who was able to attend. If you'd like more information on Safety Alliance, feel free to shoot me an email and I will send that information over to you. This session was recorded, so as soon as we get it edited and ready for your viewing, we will send a follow-up email with a link to the recording as well as Karen's information, so you can reach out to her directly as well.
Awesome.
Karen, thank you.
Thanks, Karen. Thank you, Tony.
Yep.
Yes.
It was great.